Good morning. This is Dr. Matthew Dunn, host of The Future of Email. My guest today, again, I've been really looking forward to an in-depth conversation with Freeman. Reed, welcome.
Thank you. It's a delight to be here.
You're a partner at ArentFox, and you're also the exec director of the Email Sender and Provider Coalition, correct?
Well, technically, I'm outside counsel,
Outside
I
counsel.
operate in the capacity of executive director.
I was going to say, I think you keep the trains running there. We'll talk about the Sender Provider Coalition in more depth, but one of the things I really wanted to talk with you about, because frankly, you're an expert in this space, is privacy. It seems like the world woke up not that many years ago and said, oh, this actually matters. And bam, all of a sudden it's changing and even finally reaching our shores.
Well, yeah, I've been at this for 25 years in this practice. I started at the Federal Trade Commission. And so it's been interesting to me. Up until 5 years ago, we had a certain type of privacy law, especially in the USA. Things were generally, it's either deceptive or it's unfair or it's legal. And that was a lot of law and a lot of feel to it. And 5 years ago, the GDPR took effect, and it'll be 5 years this summer. And California passed its comprehensive privacy law, which has since been amended. Since then, we've had 4 other states pass laws. So now we have all of these big, thick, comprehensive codes in privacy law now, which just didn't exist really more than 5 years ago. Europe had what was called a directive, but it wasn't an implementing regulation. So the privacy has really become a front of burner issue, a C-suite issue since then. And the reason for that is it's not just because everybody suddenly got very interested in privacy. It's GDPR, they can fine you up to 4% of your global revenue, regardless. So that's why we see fines, as high as $750 million with a B in Europe. And so, that happens a couple of times and people notice and pay attention.
So you're saying companies have actually gotten back with fines of that?
Yes. Wow. We have seen fines that high. Even in the USA, just in December, the Epic Games, I think they make Fortnite. The FTC went after them for 2 things. We'll talk about these: children's privacy violation, collecting kids' information without parents' consent, and then what they called dark patterns. We'll talk more about this. Dark patterns is another way of saying tricky language, and manipulating your. And it's kind of a paternalistic term, but there were dark patterns in the cancellation of it, and we're going to talk more about this too. The big deal with dark patterns is subscriptions that you can't get out of, fees that you didn't know you were going to pay, the things that generate a lot of consumer complaints. And so the FTC went for basically $500 million or $250 million for the children's privacy, 250 million children's privacy, 250 million for dark patterns. So almost $500 million by the FTC in just one case last year. So if that's not a wake-up call, that hardly anything is. So the FTC is on the beat, and they are really ramping up enforcement in a big way.
So put this in a sort of a simplified business context for a moment, because I agree, $500 million would get almost anybody's attention. And I'm sure it's a C-suite issue. But businesses that feel like they're still like doing things right, square, et cetera, still need to pay attention to how they're complying with privacy law, don't they?
Yeah. So there's two kinds. There's sort of what I'll call privacy foot faults. And then there's just double faults, right? So the foot fault's a technical violation. Double fault's a big miss, 2 of them. Okay. So what we're talking about with Epic Games was a massive double fault. Yeah. So and so if C-suite executives take nothing else from this podcast at all, it is obsess over your consumer complaints, because you think about it, like regulators, they sit around. It's not like they think to themselves, I'm going to investigate Epic Games. No, complaints piled up. They fed into the FTC's complaint system. They got a whole bunch of them. And the FTC then launched an investigation, and lo and behold, they found they alleged, um, a huge drove of consumer complaints, and then all kinds of messaging back and forth like, "Hey, this is an issue. Yeah, okay, and then no big deal. Nothing happens, nothing happens." And so after a while, a pattern develops and the FTC gets more and more frustrated as they go through these things. And so, backwards, if you're an executive, you look at your consumer complaints. They are the roadmap to an investigation in many cases, especially the big misses, right? So if you get a spike in complaints, you can sort of categorize your complaints. If you get a spike in a certain area, figure out what that area is and try to tamp them down, make people happy, make the more you do that, the less of a roadmap there is for the government. And so consumer complaints is one thing. The other thing, the footfalls you can make are all of these new laws with all kinds of rules and prohibitions and mandates and consumer rights and things. But you really can footfall your way into trouble with these. And that's sort of the trouble. And that's why I've been thinking a lot this spring about what's really being enforced and what do we think is going to be enforced going forward. And I can tell you right now, the big issue right now is in each one of these states, there's an opt out. In California, you can um, opt out of the sharing and sale of your personal information. And the AG, who has enforcement authority until July, is already investigating honoring opt outs. I mean, you could sort of guess if the law gives you a single really important right, that's where the enforcement is going to.
Wait,
And
July. What changes in July?
all right, yeah, good question. So a lot changes in July. Um, there's a giant amendment to this law that took effect in January, but is not enforced until July. And it's not enforced until July for things from July on. So it's not retroactive.
And this law
That's
in California, right?
yeah. So California, there's two. It's complicated.
Okay.
This the CCPA. Even my mother has heard of the CCPA. It was amended by the CPRA, and it's still the CCPA. It's just had a big amendment. One of the key changes in the CPRA is until January, you had a right to the opt out of the sale of your personal information. Starting in January and being enforced in July is you can opt out of the sale and sharing of your personal information. Sharing is not your mother's definition of sharing. It sounds bigger than it is. Sharing is sharing for basically behavioral advertising purposes. And so item two of the takeaway is there are two, well, I'll just say there are three. There's three giant bugaboos in advertising, three big ones in privacy. There's targeted advertising. I don't know why, but you put internet within 5 words of advertising, you have a privacy problem.
Yes.
You always have, you always will. And Europe hates it. Our regulators are skeptical of it. So number two is artificial intelligence. Artificial intelligence is not intuitive. Why is artificial intelligence a bugaboo? Because for some people, in some cases, it can produce a bad outcome. In hiring, in employment, in credit, it can produce biased outcomes. And because of that, the whole thing has a cloud by regulators and legislators. Number three, the less concern to email marketers is the collection of any kind of biometric information. It has become the case. You remember when if you sent a text message, you could expect to be sued. I mean, it's the TCPA. You send a text message, you're going to get sued. It doesn't matter if God sends it; he's getting sued. The same thing with biometrics now. It's the exact same. You collect a fingerprint, you're going to get sued, and you're going to have to defend yourself. And the reason is, why would that be the case? Because the law allows for a private right of action. The law allows plaintiffs, lawyers, and class actions to bring a case. And why do they do it? Because they get 1/3 of the recovery. Right. So this is if you want a law, if you want compliance with the law, give it a private right of action.
Okay. And is the is there private right of action for infringement of that sale or sharing of personal information that you mentioned?
California does not have a private right of action. I think 9 of the state bills, 9 of the 48, would have a private right of action. If any of those passes, that is a major game changer.
Yeah.
Right. Because right now, if you think about it, in most cases, the regulator can enforce the law, whether it's a California regulator or Virginia or the FTC, and they generally exercise discretion. They have what we call a target rich environment. They can go after any kind of. They actually say that out loud. I love that phrase. So, uh, they have some discretion in what they go after and how they go after it. And they exercise discretion, and they do bring really bad cases, but not always. They generally, over a long period of time, in a lot of cases, generally they pick the low hanging fruit. Not so when there's a private right of action, because there's no discretion. The only thing that matters is the plaintiff's lawyer thinks he can make 1/3 on a bunch of money. That's the only thing that matters.
Right.
And so think about this. You collect fingerprints or a voice print or a facial scan. Um, the plaintiff's lawyer is going to go after you and say that you violated the law in Illinois that prohibits certain types of collection. Now, this is America. It's not loser pays. You, Michael or Matthew Dunn, have to pay to defend yourself. And you're going to pay and pay and pay until you file what's called a motion to dismiss to get rid of the case. And let's say you win. The plaintiff's lawyer knows what that costs. Let's say that costs $75,000. Hey, for you, I'll settle for 50. So they hold you hostage for the legal fees. And that is where we are with the biometrics. And that's where we will go if there is a private right of action in all these comprehensive laws.
You said it blew right past it. Voice print. Does that mean a recorded call is a potential cause for this kind of private action?
Oh, there's a different right of action for that.
Okay.
So let's parse that out. What is a voice print? The biometric laws put certain requirements and prohibitions on the collection of a biometric identifier. So it has to be, in the case of a voice print, it has to be your voice in a way that I could use to identify you. Okay, so it would be at the unique aspects of your voice, the ones and zeros that go with a digital collection of your voice, just like a face scan is just facial geometry. Okay, so it's not just a recording. Now, there's a whole other set of laws that prohibit there are 12 states that require two-party consent to record. So if I'm on the phone with you in 38 states, all I have to do is give consent. The whole thing can be recorded. But in 12 states, you also have to consent.
Hey, by the way, we're recording this.
I got the disclosure. I got a big opt-in thing.
Got a big opt-in on screen when I clicked record.
Yeah.
But can't you derive a voice print from a recording?
Yes, you could, but I think the plaintiff would have to prove that you're using the voice print to identify me, not just to listen to my voice later, but to identify me as among others.
Okay.
So that's why the classic example, who's being sued the most in these biometric cases? Employers, because it's the clock in, clock out. There's a whole set of technology for clock in, clock out based on a fingerprint. And how employers in Illinois don't know that there's a sledgehammer that's going to fall on their head. I don't know, but there's an entire group of lawyers who are looking out for that and bringing cases.
So
think about this. So there's another set.
The gold rush it's akin to the gold rush that happened in
1848.
ADA. People getting sued because their website's not ADA compliant. It's that
very, very similar to that. And the reason is because the law provides an incentive for lawyers to find and bring cases. So think about this. This is kind of funny. It's not intuitive until I say it out loud. But which came first, the lawyer or the client? The lawyer. The lawyer finds the case, recruits clients, and then sues you. So yeah, it is a gold rush. And think about you think about facial geometry, how common can that be? Well, all of a sudden, uh, there is a whole bunch of the whole class of these cases being brought against virtual try-on technology. So I go to a website to try on sunglasses, and it has to take facial geometry to let me see what I look like with sunglasses, or jewelry, or makeup, or a haircut.
Yep.
There are, I think, 5 different sets of class actions going after virtual try-on services,
Wow.
which I think is you'll see how these shake out. But these are things that are increasing in popularity. Consumers like them. Everybody likes them, but there are certain requirements and prohibitions in the law when you collect any kind of biometric identifier.
Hmm. So you're focusing, I think, on the laws that are likely to be enforced. And it sounds like where there's a private right of action, the likelihood of action and enforcement goes up. Fair?
Mm-hmm. Yes, that's right.
And also the more commonly something is practiced, maybe not for the obvious reason, but like I wouldn't have thought of makeup and try on as biometric, but yeah,
That's because you don't get 1/3. So, uh,
yeah,
so
a fair point.
let me talk about something else that I think we're going to see a lot of this year, and I've started to see other lawyers say this too. Um, the by the way, if you didn't know why weren't satisfied that targeted advertising is a bugaboo and in privacy, the Federal Trade Commission has coined the term surveillance advertising. Same thing. It's now surveillance advertising. Here's the warning that I think we're going to see a lot of is dark patterns. So as we talked about earlier, a dark pattern, according to the government, is any kind of user interface that would cause you to do something maybe you wouldn't have done otherwise. Okay. Pause and think about that definition. And then tell me, how would you define sales?
Yeah, really.
so
Pretty much, right?
so a dark pattern can be anything from it's really easy to subscribe to something and it's impossible to get out. Which, by the way, is pretty common. It goes all the way to uh, any kind of choice where it's, yes, I agree, hit green, and then a no thanks, or worse yet, options, or, tell me more, where the choice isn't symmetric. Yes, no. That, according to the government, failing to have a yes, no, where there's a yes, there should also be a no, is all it's by itself a dark pattern. Another one would be a false sense of urgency. Hurry, sale ends in 8 hours when it doesn't. That's pretty common, right? Only 3 left. These are pretty common sales tactics to drive demand, which are suddenly illegal. Now, where the reason I'm focusing on enforcement is when you take that to the logical extreme, really common things are flat out illegal. But where is the enforcement going to be? Is it going to be all the way at the extreme, or will it dial back? Where's the gray where business will operate, and as opposed to the red and the pink where the enforcement is, right? So that's always where business operates, a little bit in the gray. That's where the market usually is, except for banks except for some banks. But so
We're
anyway,
just after SVB fell.
no, I don't.
Context, listener. That's why
I have no comment on any of that.
no comment on any of that. Right.
So, I think we're going to see one thing the market hates more than anything is uncertainty, and we're in a period of uncertainty now where the government is saying all these things are illegal, and the market is used to doing a lot of these things. So where is the line going to be?
Yeah.
But I think what we're going to see is any kind of fee at all that's being charged, whether the FTC refers to most fees as junk fees. Okay, so any kind of fee, any kind of what we call a negative option free trial, where I get 7 days for free. Then if I do nothing, I continue to enjoy the service. And oh, by the way, I'm going to be charged every month. Okay. So
really,
these that's a negative option free trial. That's a legal thing. But consumers complain. There's a new app that's advertised on TV all the time. You got unwanted subscriptions, download this app and it'll get rid of your unwanted subscriptions. This is a big thing in the market right now. It's a lot of anytime you can get recurring revenue, it's a driver. So we see a lot of it, and naturally we see consumers reacting to it, and a lot of consumers complain. So I think these kinds of subscriptions, negative option, trials, fees, if you're getting consumer complaints, people probably don't understand what's going on, or it's too hard to cancel. So you have to adjust things to keep the complaints down and just run faster than the other guy the bear's chasing.
Hmm. So let's drill into the subscription thing a little bit, because as a SaaS company, we pay attention to this. So we, Campaign Genius in my case, because I wouldn't have thought that trial period then subscription could be interpreted as a dark pattern. Now that you say it out loud, it makes sense. How much is a SaaS company who operates that way, freemium or trial and subscribe? How much risk are they at if they're small?
Okay, let's unpack that. A negative option free trial, like you described, is presumptively legal.
Okay.
What makes it illegal? What makes it illegal is when people don't get it. Okay. So in consumer protection law, then the beautiful thing about consumer protection law is the law is what it should be in almost all cases. So in consumer protection law, you're not only liable for what you say, you're liable for what people take away. Not everybody, not the idiot. It's called the village idiot standard, but the reasonable consumer. What the reasonable consumer takes away. New York, it's the village idiot standard. Most states, it's reasonable. So, if you think I'm conveying that this is free, but you got to give your card, and after 7 days you're going to be charged, and then every month after that this amount. If you think you're conveying all of that, but you're getting a flood of consumer complaints of people saying, "What? Why am I charged? And why can't I get out?" You've got a problem with that. You need to be more clear.
Yeah.
And where's the market? The market's probably not where it should be right now. It's probably going to shake out the more cases the government bring. But it's not illegal to offer a negative option free trial. It's illegal when people don't get it. And when you're aware that people are confused and have been and feel like they've been victimized. So the law is what it should be. It's I always joke, my mother would be a good consumer protection lawyer because, she's got good sense. and
Right.
and so that is so I want to clear that up. Nevertheless, subscriptions, fees, these are things the FTC has said over and over they're going after. And so why does this matter for email, right? Let's bring it back home. Um, it's curious. There is, so you've heard of aiding and abetting, right? Let's say you rob a bank and I drive you away, right? I'm the getaway car. Well, I've aided and abetted grand larceny, and right because I helped you. There is no aiding and abetting for the FTC Act. So what do? They made up something that's the same thing. Their statute doesn't allow for it, but they made it up, and courts bought it. So it doesn't really matter what it's called, means and instrumentalities, but it's the same thing. I provide you the means and instrumentalities to commit fraud. And we see this in telemarketing a lot. So you think about a company has a freemium offer and an ESP helps them deliver it.
Mm-hmm.
Well, if the government can show the ESP knew or should have known this was a problem, they can go after both. And they go after the brand and the email provider. So you're not inoculated by just being by burying your head in the sand and having a client. If your client's engaged in deception, you're on the hook too. And so the FTC has said for generations, companies should do due diligence on their vendors to make sure they're not crooks, right?
And vice versa, right? Vendors.
So what we're seeing now is the FTC saying vendors do due diligence on your brands.
Customers, yeah. I was gonna throw a specific example at you because this is gold, man. Thank you. We have for years used a subscription management platform as part of our SaaS service, and one of the configuration options in that subscription management platform is notification about renewal, right? Hey, just a reminder, your subscription is going to renew at the end of the month or at the end of the quarter or at the end of the year. And I've always thought you should have that on, right? It's
Right.
like the decent thing to do, but not
Right.
everybody does that.
Well, yeah. How many times have you gotten that for a subscription you've entered into yourself?
Yeah,
And so,
frequently,
so, that I would say that that's a best practice,
right?
whether that's required by law, I don't know, depends on who you
Interesting.
ask,
Interesting.
but what does that accomplish? What that accomplishes is people who don't want the subscription or frankly, who are too lazy to get out of it, don't. And then they don't want to complain because they got the notice, right?
Right.
If you don't have that and your complaints pile up,
Yeah.
you have a problem. So I want to circle back to this. If you take nothing else away, your complaints are gold.
Yeah.
The government, the rule of thumb is the government gets about 1 in 100 of what you get. And they get them long after you got them. Because how many times have you complained to the Federal Trade Commission? I'll bet 0,
Pretty much. Yeah.
right? Okay. But how many times have you complained to a company? You just written an email, been frustrated? A lot, right? So there's a huge multiplier. So you have an exponentially more than the government, but they're typically the same. And you get them earlier. So you have a chance to tamp them down before the government sees a problem. And the government really does uh, sift through. The FTC gets millions and millions of consumer complaints, and they run all kinds of programs on them to see trends, what's trending, what are people complaining the most about, what's new, what's old, and then they prioritize the cases they're going to bring. You just don't want to be in that mix. That is where you don't want to be.
Yeah.
And
Yeah.
it's remarkable how often that simple admonition is something no one's ever thought about. They'd say, the customer care will handle that. You know what? Actually, not. Legal should be in there looking at the complaints, raising it with management, saying, "This is the spike I'm seeing. We've got to get this down."
Well,
Um,
I'd actually I'd extend that further, and I'm going to hook this back to email in a kind of a funny way. I think a lot of companies are guilty of using email as a one-way channel. At send. Have you ever gotten an email with a no reply as the reply
yeah,
address?
a
Raise your
lot.
hands,
Yeah,
kids.
yeah, yeah.
All of us, right? And you're like, why is it so freaking hard to talk to you? You're willing to take my money, but you're not willing to listen to me? Give me a break, right? And would it help to? I'm paying attention to complaints. That's the headline for this one now, this episode. But can do we help ourselves in making it easier for our customers to talk to us?
Well, that's probably more than is required, but you hit on something really important. Uh, the FTC has long taken the position, but now they're suing on it a lot, that it should be as easy to get out as it is to get in.
Sure.
Now that seems easy and obvious until you're running a business and you don't pay attention to that.
Yeah.
So yes, it when it's easy to subscribe and get your money taken out, but then you can't figure out where to cancel, and you go and you get this endless loop,
Yeah.
and a bunch of screens. And are you sure? Are you sure? Are you sure? This goes on and on. You can't actually do it. That's where the government steps in and says there's no symmetry here.
Yeah.
There should be symmetry.
Yeah. Yeah.
By the way, back to your SaaS thing. This is important. So where's the enforcement? The law is the law. Well, whatever it is, it applies to everybody. The enforcement is not on B2B. By and large, I mean, unless it's B2B with small mom and pop shops,
Yeah.
which is basically consumers, the enforcement is B2C. So if you're a consumer facing brand or you're a vendor for a consumer facing brand, that's where the enforcement is. The law is the same. It's just that if General Motors goes and complains about Ford, the FTC will say, "Good grief, if you have a way bigger budget than we do, you deal with it."
Yeah. Yeah. That makes sense. And yeah, I guess at the end of the day, the the consumer is the citizen or closer to, right?
Right. Yeah.
A lot of the laws and focus of the laws is those of us vote, pay taxes, all that other stuff.
Right.
Okay. Okay. So B2C brands should pay even more attention to their customer complaints. I think B2B brands should, obviously, but
Yeah.
yeah. Okay. So you're saying it matters even more in the B2C space. You said small business. Like I get $500 million suit. And I know what Fortnite is and was, so I wasn't entirely surprised. I get the $500 million suit. Should the smaller B2C business still pay attention to this stuff from the very beginning?
Yeah. You know, this is something that's deeply frustrating to me and others. Uh, you look at the cases the Federal Trade Commission has brought in the last 15 years, which is basically they started bringing privacy cases 25 years ago. They've enhanced a lot over the last 15 years. So many of them are against companies you've never heard of. Why
Really?
is that?
Huh.
Yes. Why is that? Because they don't have the resources to fight back. And what happens is they agree to what's called an order. So they will agree to make the case go away, to end the bloodletting of legal fees and the production of documents and all of that. They'll agree to an order, and then the FTC will write its complaint and its order provisions and get a little bit more than they could have gotten from a judge. And then that becomes the going standard. So they're making law on easy targets. And this is over and over and over again. So it's curious. The FTC will talk about its cases as though they were decided by the Supreme Court in an opinion. They weren't. They were settles. But there was an agreed settlement to make the case go away.
Yeah.
And that becomes what we call precedent for the next case and the next case and the next case. So when the FTC will talk about its privacy enforcement, they rattle out the names of these cases as though they were litigated decisions with a judge deciding. They're actually not. They were agreed by a lot of small companies to make a case go away.
Which seems rather loose.
Well, I mean, it's a good strategy. It works. So, I don't want to trash the FTC too much. I mean, that is something that I'm frustrated with. But by and large, they don't bring a lot of cases that they could, even if they think they could win because there's bad cases.
You see if I can link two other things together that are through lines in what you've said. One is lawyers, and the other is data and privacy. Let's call it practices. Let me take the second one and then the first one. Second one, I would hazard a guess that most companies of almost any size actually have god awful records about who said, yes, you can store this. Yes, you can have this. Yes, you have permission to communicate with me, etc. Like it's one of those things that we all talk about, but in practice, if someone said, you got Reed on your newsletter, when did he sign up? Shit, I don't know. Like there's a record in there, right? But if you came along or your lawyer came along and said, oh, we're going to pounce on you because you don't have permission to do what you did with Reed's email address, my top line reaction would be, oh man, lawyers are expensive, aren't they? And really the big fulcrum in all this is the cost of the legal action is it's so high that your average business just goes, hey, how do I get out of this? How do I stop this?
Yeah. Yeah. Well, the one of the things that's interested me since I've been with the ESPC since 2010, and the ESPs legitimate. We always talk about legitimate ESPs and not legitimate. So what's I think people will be heartened to hear is that legitimate ESPs generally think the law is higher than it is. Oops, I'm sorry about that. Sorry about that. They generally think the law is higher than it is. The CAN-SPAM does not require permission-based emails. It requires an opportunity to opt out. California tried to pass an opt-in email bill in 2003, and that's why we have CAN-SPAM, because they did pass the law. It was going to take effect, and business went to Congress and said, absolutely not. And Congress passed CAN-SPAM, which had been sitting around for 5 years.
Okay.
So, but it's a best practice. And what does permissioned email do? First of all, better response rates. Second of all, you get more engaged people and you get less complaints. So, the legitimate, the ESPC has a requirement for members to do permission-based emails. That's a membership requirement. But that's an industry standard. And so I've always been hard. People talk about spam and marketing emails. And I always say, this industry operates at a higher level than a lot of others. So, but you raise a good point. It is becoming more and more important to have records, compliance records, for how you're complying with these state laws, how you're complying with the GDPR, because when the regulator comes, they expect you to have all of these records, which takes me to another point. Let's turn that upside down. Some of these laws require what's called a privacy impact assessment. I've been thinking about this a lot lately. If you're going to do a certain kind of profiling of people, you're going to do certain kinds of automated decision making, these laws will require a privacy impact assessment, which is literally this is what we want to do. These are the risks. These are the mitigators. So we think it's okay. Good grief. Like, these are the risks. Really? You're going to write that down? And it's not privileged. So no one's talking about this. This document scares the wits out of me because you're now required to have this. You're required to keep it and produce it when the government comes calling. And it is a roadmap to all of your own anxieties that you have to write down now. So we'll see how this shakes out. But I am a big advocate of having like legal do this and keeping it privileged, because if you really want to be honest about it and do it right, you have to write things down that you really wouldn't want other people to see. And that's the tension here is, how can you do a legitimate one and survive discovery? It's a problem. And of course, this just rammed through the CCPA. The California Consumer Privacy Act went through the entire legislature, was signed by the governor in 1 week, 1 business week. If you are on vacation, you missed the whole thing. So did anybody read it? Did anybody think about it? Did anybody talk about stuff like this? No, it just rammed through and was signed because it's consumer privacy. So this is all going to shake out over the next several years. This is all new, and we'll see how it shakes out. But this is just one of the issues that's a big problem.
You know what? It's such a delight to have an expert in this space. I get to pick on you. Go wide for a second. Why is the U.S. so different on privacy issues?
Yeah, I've thought a lot about this too. So let's just call it what it is. The rest of the world, I mean, China, Russia, Nigeria, I mean, countries all over the world have comprehensive privacy laws. China and Russia, think about that. So, and we don't. Why is that? There's a reason. In 1974, we passed the Fair Credit Reporting Act, which is our first wildly big privacy law. And it's exactly where it should be, credit, right? Where bad things can happen. The Privacy Act for how the federal government treats people. Why do we have that? Richard Nixon. That was in the early 70s. Then we did the Children's Online Privacy Protection Act, Cramley-Schplally for health, for financials, HIPAA for health. We have all these laws that have built up, and then suddenly Congress says we want a comprehensive privacy law. Guess who stands up and says, not me? All those people. I already did my law. Not me. Not me. Not me. And by the way, if you do it, you got to do it this way, that way. So it's almost like we matured without it, and now it's really hard to go back and put that coat on. It's just what happens time and time again is it gets introduced, then a bunch of people come in and want their own ornament on the tree, and it becomes too big. It becomes, you just can't get it through. There are too many interests involved and it's too hard. I'm not sure we'll ever have one, especially now that we have the state laws. Companies spend a lot of money doing CCPA. They don't want to do a whole new thing.
Is California such a big part of the economy that CCPA becomes sort of the de facto standard?
Yes, that's a great point. So we have all these laws, but what you're seeing in the market is people benchmarking to CCPA, and they may do are they saying like we want to put all of Utah in, Connecticut, Colorado, Virginia? What you're seeing in the market is a lot more of let's do CCPA and then do the big stuff from the other laws that we have to. So CCPA is big enough, it's hard enough, it's enforced enough that it is the de facto standard.
So the de facto standard that got rammed through in a week, right?
Right. And then amended. This is funny. It was was a very long single spaced red line of that was put to the voters as if the voters read a giant
Yeah,
single
right.
space red line, but it said consumer privacy, that amendment passed a voter referendum. So, you know, if this is what we're seeing now, it's once something says privacy and it gets a little tailwind, it's hard to stop.
It's hard to stop. I I don't think it works that way, but I find myself thinking that legislatures in other states that don't have a bill yet should find a way to go, yeah, what they said down there in California.
Yeah. Actually, we're seeing a lot of that, but in many of the 48 bills do tailor to a certain standard. The problem is they don't all, and we don't know what's going to get out.
Yeah,
And all you
yeah,
need is a few big differences, which create a giant headache. And for what marginal gain, right? Not
yeah.
much.
Well, yeah, not much marginal gain, but plenty of marginal risk because
And headache, right?
some lawyer in fill in the blank state is going to go, oh, you have a consumer here. Guess what? Our law is different. Um,
Right. Right.
Hi, we'd like to talk to you.
Yeah, that's why the there are all these bills and they can be different and we can raise our hands about it. But the ones that have a private right of action, where a class action lawyer can bring a case, those are the ones that would really be an entire game changer.
Is it fair in a conversation with a lawyer to say that we the rest of us are a little frustrated and sometimes confused by the stick the legal profession swings in terms of cost and risk? It's
Yeah, it's entirely fair. It's entirely fair. Um, the I think the rejoinder would be from the enforcers would be if there was no stick, there'd be no compliance.
yeah,
And then the bar that helps you would say if there weren't enforcement, you wouldn't need us, but there is, so you do.
yeah,
So um, that's why it's important if you're going to hire a lawyer, who doesn't have to learn this all on your dime. It's complicated,
yes,
and
it's
it's
complicated.
really I get about 10 newsletters every day,
Yeah,
and I would say that privacy law, and this is the one thing, whole things I know this one thing very well. It changes about 5% a month. So it's 5 years. It's an entire rewrite. And that's a lot of law. I mean, there are books this thick that are like some of the privacy law.
yeah.
So it's a lot of law. It's a very, very dynamic area. But circling back, sure, you can commit a footfall, but what are the big things you need to do? Watch your consumer complaints and watch your spikes and honor consumer opt outs, honor consumer requests. If a consumer's asked you something, unless there's a good reason why you can't do it, you should do it. Because if they don't get it, they're going to be frustrated and they're going to complain. And so that is what the enforcement we're seeing. And then this whole dark pattern business, really, it ends up in deception and consumer complaints for being frustrated that they
Yeah.
can't get out.
Well, I have to say, I mean, a sample set of one, so not a big sample set, but on as an active SaaS business with all of the subscriptions and dependencies and services involved in running a SaaS business, I, I think there's been a shift in the mindset of SaaS companies, at least the ones that serve B2B, okay, of being better about doing the right thing. I just had an interaction this morning, seriously, 10 minutes before we hopped on this call, where I'd essentially opened a duplicate subscription and not realized it. Mea culpa, right? Idiot. So I wrote the company and I said, oh, I already have one and I'm using this one. And they said, oh, no problem. Close that one down. We'll credit, the other one. They kept the revenue. They kept the customer and they got me very happy. They'll probably have me for multiple years. And it wasn't actually that hard. And it used to be a huge pain in the patootie when you'd run into a situation like that. You wouldn't even know where to look or who to call. So I am hardened that I think businesses, it's like the online space is growing up a bit.
Yeah.
Like you could hide behind, oh yeah, you can't find us, so we'll just keep charging your card. But that doesn't tend to last. And a noisy consumer or an unhappy customer has a very loud voice. These,
Yeah. Well, what I think we're going to see is, and glad you raised that, is the online world really is no longer looked at as a child anymore. It has to be a
Right.
grown up
Yeah.
like everybody else.
Yeah.
But what we're seeing now is uh, the same sort of start from the beginning with AI. So
Oh, God. Yeah.
what so we are at, and we've talked about this before, but we're at like midnight and half a second in AI right now. And look at what it can already do. Who knows what it'll be able to do, but it is generating all the same issues in intellectual property and privacy that the internet did when it took off,
Yeah.
and the iPhone and every new technology.
Yeah.
But it's going to be fun to watch AI grow up and to see it develop. And it's been interesting to see the difference in approach with Europe and the USA. Europe saw AI out of the glimmer of somebody's eye, said, quick, we have to regulate it. The US said, you know what, this has a lot of promise. It can also do a lot of harm. Let's watch it very closely and
Yeah.
see how we should regulate it.
Yeah.
It's a very different approach, top down to sort of manage. But we'll see who got it right. But the US has been more hands off, and the Europe has been, shackle it from birth.
That's fairly consistent practice. I tracked the rise of mobile pretty closely, as a technologist. And the US, we had all the science experiments of different standards, different carriers, yada, yada, yada. Europe, it was like, we will declare that we're using this technology, everyone will adhere to it. So we jumped out early. Then they leapfrogged us with more common usage across countries. Then we had to play catch up and start. Basically, the market had to force carriers to get on board with common standards. Like that's how we
Right.
do it, right? It's
Yeah.
Marie
Well,
Mazzucato
and I
States.
and I have a US bias, of course,
Sure.
but you know, it is actually true that there's not a lot of VC money in Europe. There's not a lot of entrepreneurship. There's not a lot of startups. There's not a
Yeah.
lot of
Yeah.
innovation in Europe. And there's a lot of companies fleeing Europe. Why? Too much regulation. And GDPR is just one example. Everything they do is like that. So,
Yeah.
I've always joked, it's impossible to read the GDPR from beginning to end in one sitting. It's impossible. It can't be done. And so, I mean, there's a lot of law, and there's a lot of I dotting and T crossing in Europe. So, I mean, there's a reason why their innovation's not where we are.
Yeah. Yeah. And we'll keep figuring out that balance as we go along. There's also a culture thing. Like,
Yeah.
let's just call a spade a spade. Like, we take some of the lumps for leaving it a little looser and then catching up later, but we get some of the what we see as gains. And I imagine someone in Europe would say, "Oh, you guys are
Yeah.
working too hard, right?"
I don't buy it. I go to Europe. I was just in Europe last 2 weeks ago.
Right.
You cannot swing a dead cat in continental Europe and not see a CCTV camera recording everything you do and everywhere you go. They're
Okay.
everywhere.
Wow.
And they have a giant, huge privacy law.
Yeah.
For what? I'm recorded everywhere I go.
Yeah.
So we don't have those.
It's true.
So, there's a lot of law for law's sake without with missing the big picture.
And too bureaucratic for my taste. Well, Reed, I promised I would not tie you up all day, and this has been one of the most fascinating and educational conversations ever. What's your parting advice to someone who listens to this and says, "Okay, pay attention to my consumer complaints, check. Pay attention to CCPA, check." Like, when you talk with someone who runs a business, what's the most common? Gosh, if you just do this, should make your life easier. Aside from those two pieces of advice.
Yeah. So there's the things that I've talked about, but also what I want to impart is this is all changing wildly quickly.
Yeah.
The risk framework. What is risky now is going to be different than what's risky in the fall next year this time. It's too dynamic. So I would say, you should work with somebody you trust, a lawyer you trust who knows this space, and just have a periodic call, like a checkup. What's hot? Because it changes a lot. And The sort of unknown thing is the government assumes that you know what's important to the government. They just assume that. And when you misstep, you might think, I haven't done anything wrong. If you're misstep in a way the government doesn't like, they're going to bring you a case and wonder what's wrong with you. So a little checkup for where are we and what's important now, I think is worth its weight in gold.
That is
Doesn't cost that much for a quick checkup.
terrific parting advice. Reed, it's been a gas. I look forward to further conversation live when we're together at a couple of conferences.
Okay, terrific. Thanks so much for having me.
All right, we're
All
out.
right.